you can see what I said that in the introduction, that this course is designed to familiarize students with essential ingredients of thinking about law. I think that that's an important point that you should note, that we are thinking about law. We're not practicing law or doing law or, or whatever. We're thinking about law at a high level of abstraction. So I guess that's what it's about. We're thinking about law at a high level of abstraction. What does abstraction mean? Abstract. When we say we are thinking in an abstract manner, what does that mean? Please, can someone volunteer and tell us? Abstract thinking.
Good
Okay, what's
morning.
abstract? Go on.
Okay, I would say that abstractly is something that it's not very concrete, but it's leaving everything to the imagination. I won't say leaving everything to the imagination, but like more what's the word? Just not as concrete as it is in practice.
Lovely. Can anyone else help us? Don't be shy. You know, those of you who did petroleum and energy must know my style. Like we are all here to learn. We're not here to castigate, and that I would rather you made a mistake and learned than keep quiet and die in ignorance. Some people don't mind dying in ignorance, but I mind dying in ignorance. I don't tell you questions, I don't tell you answers. I want you to find out, to discover answers, and we discover it together. Okay? I know that you have access to Google and all those things. So let someone tell us abstract thinking. What are we talking about?
Good morning, sir.
Good morning. Can you please tell me your name when you greet me? That way I will know as well for a few seconds anyway. That hmm? Thank you.
My name is Aisha.
Lovely, Aisha. Go ahead.
Okay, if I was going to describe abstract thinking, I would say something that is steeped in theory. It is not intended to be applied practically per se. Yeah, that is what I would
I
say.
think that's a very good one. Anyone else? As we said, we don't castigate anyone.
Good morning, sir.
Good morning. Go
My name
ahead.
is Olamekwasi.
Thank you. Go ahead.
So I think abstract thinking deals with thinking that is not attached to a physical object or physical visuals of any sort.
Okay. So basically, all what you're saying, they are all correct in your different ways. We are looking at abstract thinking. We're looking at about how it applies in our class of jurisprudence, and we are looking at how we can reason beyond the legal rules or cases that we can see. How can we reason beyond it? What are those things, those underlying theories, those underlying philosophical questions, those underlying concepts that actually are the ones that are shaping what law is, what's shaping justice, what's shaping what the law, So we're looking from what the law is to why is the law the way it is, or what should the law be? Does that make any sense? We're not looking at, okay, this is the law. When I open a statute, that's what the law is, isn't it? I say, okay, let's go to Kama. You open Kama. What we are seeing in Kama is what? The law. Am I right or wrong? We are
Yes,
looking at
sir.
the law. Yeah. So what the law is, but in our own case, we are not looking at just what the law is, what the law is saying. Kama is saying this. Kama is saying that. Land Use Act says in section 1. What's that Latin phrase you all like? I know it's not in section 1. Planter, solo, something, something, credit, whatever. Who can remind me of the Latin? I know you don't love Latin. That I know. I have been
Qui
told that.
plantator solution.
That's it. That's it. Fantastic. I know that you guys, to intimidate your friends in your hostels, you start to say a quick planter. This will be looking. Ah, this guy is not easy. Oh, no. But we all know it's not. There's not much going on there. So, but when I open the legal book, when I open the textbook, what I find is that I find what the law is. But what I don't know is that why did why was that law created in the way it is? Why is the law the way it is? And what should the law be? Because it's not every law that satisfies every need. Okay. For instance, let's remain with Land Use Act. Land Use Act is a very powerful act, 1978. It's so powerful that it's been enshrined in the Constitution. Is that not so? That's what the law is. So why is that law the way it is? Does anyone tell me why is Land Use Act enshrined in the Constitution? What's so special about the Land Use Act? Just volunteer. There's no, I have said we don't castigate whether you get it right. There's no right or wrong answer per se. It's the thinking. We're in the course of thinking. We want thinkers. We don't want the ability to engage with material, with text, to read a text and think about the implications. That's what we are here for. So, Land Use Act. That's what the law is. You've read it. You have passed year 4, hopefully. I guess most of you have passed the course. Those who have not passed, I wish you well, because that's a compulsory course. Why is the law the way it is? Why is it enshrined in the Constitution? Why does the Constitution mention Land Use Act? Or doesn't it? I've forgotten my Constitution. I don't think. Who wants to help me? Should I look for a volunteer? Babarinde, can you assist us? Babarinde, Bernice, Sayomi.
What I think that why the land is entrenched in the Constitution, because Constitution is the fundamental law of every other law in the land, and it should be linked with the Constitution according to
why enshrine? Why is Land Use Act important? And why is it enshrined in the Constitution? There's no right or wrong answer. Just say, go ahead.
Okay, so according to section 1 of 3 of the Constitution, it should be consistent. I mean, that should be consistent with this law, and if it's not consistent, it should be null and void. So I think that's wiser.
I'm not too sure I follow you, and also your line was not very clear. Maybe someone else can assist us as well. Any volunteer?
Yes, sir.
Go ahead.
Hello, sir. Yeah, I'm Miriam. Yes,
Miriam, go ahead, please.
Okay, sir. So basically, the Constitution is considered the ground norm, and so because it's the ground norm, anything that actually is inconsistent with the provisions of the Constitution will not be valid as a law currently. So that simply means for the Land Use Act or land law basically to apply, we need to put it in the Constitution that okay, this law would the Constitution is not against it or something, and so section 1 sub 3.
But what I don't is Kama mentioned
in the Constitution?
Yes.
I'm not sure, but I believe the Constitution provides some exceptions to certain laws, but I would say I'm not that knowledgeable to speak on it. So yes, sir.
Okay. Anyone else?
So can I try?
Please go ahead.
Okay, my name is Irayomi. I think because land has a lot to do with the essence of human living, probably because it has to do with provision of food, shelter, even the air that we breathe. So it's very fundamental to humans' lives. That's why they decided that it should be entrenched in Constitution.
Okay, so can I add to that?
Yes, please go ahead.
My name is Aisha. I would say that in addition to what Gold said, I believe the Land Use Act was enshrined in the or entrenched in the Constitution, because of the intricacies, the numerous steps that needs to take place before the Constitution itself can be amended, right? And so it's to ensure that the Land Use Act is not easily susceptible to change because of the reason.
Exactly. But why? That's why I asked you. Why is Kama not in the Constitution like the Land Use Act?
Well, like Gold said, the land user concerns land, and land is very, very essential to man's existence, right?
Okay.
And so, because of how essential it is, the right to own land, the right to
Okay.
have access to land and everything that comes with it.
Can I ask you guys as to whether when you were studying the Land Use Act, did you try to read about the history of land use, or like what happened? Why did the drafters come up with the Land Use Act? Why did they say that the governors should control the land should be vested in the governor? Why did they do this? Why did they take away land that had always belonged to families, that belonged to communities, that belonged to individuals, and they enshrined in the governor? Why did they do that?
Sir, can I try?
Yes, please try.
So my name is Rahima. So from what I remember of the history of Land Use Act and in land law, it's because land was vested in the family, as we all know from before land was
sure, go ahead.
Land was vested in the family, and they found that people that owned land were not using the land. They just had it and they were keeping it and they were passing it down. And so because the government wanted to start using the land to build
for development,
like roads and hospitals and things like that, they decided that it would be better if they were able to get some of this land and put the governor in charge of it, so that any development that needed to be done could be handled specifically by the governor.
Exactly.
It was for public purposes.
Exactly. It took too long to be negotiating and fighting with each family and each person to create a road. Imagine you're creating a road from Victoria Island to the border of Lagos State with Ogun State. Imagine how many people's lands you're going to cross if you have to be negotiating and talking to each person or family individually. So it was for developmental purposes essentially. But does that mean it's right fundamentally to deprive a citizen of their property for the greater good? I think by saying greater good, I think I've probably just like prejudged the situation. But you know what I mean? That is it right for government to have the right to take away people's land, and sometimes why how come governors and even the minister of FCT, they allocate lands? Even till today they are allocating land. The governor can give me land. Why should the governor be able to give me land? They can seize land, take over land, and give it to somebody else. Of course, later on you challenge it in court, of course, that it was not used for public purpose, which is why that's the limitation on their rights. I'm just trying to what this purpose is about is for us to jurisprudence is abstract thinking. It enables us to analyze foundational concepts such as what is our rights? What is justice? If you take away my land, don't I have a right to land? Do I have a right to land? Does the right of the individual supersede the right of the community to development? Do I have a right to justice? When you take away my land as the governor and you reallocate it to your friend or to your family, that will not work. But if you allocated that land to a school, then that will be perfectly acceptable. What about issues about so basically we're looking at concepts like rights, liberty, obligation, whatever. But we're looking at it not as legal terms, but as philosophical ideas that have different interpretation. So we need to understand various legal theories. Those legal theories that underpin our laws. So our laws were not created in abstract. We also need to be able to connect different aspects of law. Law, you find that one of the topics we will look at is law and morality. Is it law that influences morality, or is it morality that affects law? Does politics play a role in the creation of law? Does economics or social change play a role in how we treat the law, how we reason? How do we interpret complex legal philosophical texts? When I was doing jurisprudence at the University of, I just launched basically into, I think we all know who I am now. We met before, haven't we? I'm supposed to introduce myself. I can't ask all of you to introduce yourself because how many people are in class? Probably less than should be. But how many people are in class? Less than 200 out of 300 plus. Yeah. But what I'm trying to say is that we have to know foundational things when we deal with jurisprudence. I will assume that my class rep is now in class. 30 minutes after class. Class rep, can you identify that
Yes,
you're in class?
I'm in the class. Good morning, sir.
Thank you. Thank you. At long last. I didn't know that I have to query my class rep. Class rep is our leader. Class rep will be the first to. You are first to be in class. You are first, last to leave class. That's what it means to be a leader.
Yes,
so,
sir.
well done. Thank you so much. All right. So, where was I? What was I saying? Class rep came online. What was I saying?
You want to introduce yourself, sir?
I'm sorry?
You want to introduce yourself, sir?
Yes, should I be introducing myself, or you don't know me? That's why I'm asking. I mean, you didn't all do what's it called? Energy, petroleum and energy, and you didn't all do mineral law, I will assume.
No, sir.
So you don't know who I am. Hey,
we know
don't
you,
know.
sir.
Disaster. Disaster. You don't know who I am. I am Dayo Ayuade. Go and Google me. That's why you should, if you should know all your lecturers. It's not right. If I asked you about which lecturer teaches what course, you should, even though you don't do that elective, you should know who they are. It's very, very important. I unfortunately for me, I was not able to attend the University of Lagos, so I attended the University of East Anglia, Norwich instead for my LLB, and later on I did my law school in Nigeria at some point, and then I did an LLM in maritime law at the University of Wales, Cardiff. I also did later on, much later, LLM in resources, that's specializing in oil and gas. Did a PhD also in Dundee in energy law and economics. Okay, so you can see that I'm a multidisciplinary person, and that should tell you that every lawyer must be multidisciplinary. And philosophy, what is behind the law? If you just talk about the law and you look at the law, you cannot appreciate the law unless you know what underpins the law. What's the thinking? What was in the minds of the draftsman, they usually say, or draftsperson, when they were writing the law? In the UK, for instance, we have Hansard. You go to Hansard, and Hansard will document how the law was being changed in different committees and why the law was being changed. We don't have that advanced level of thinking of the law in Nigeria, sadly, because we've politicized everything and everything's about politics. But that's a matter for another day. So I've been talking about philosophy. I've been talking about law. I've been talking about nature of jurisprudence and legal theory, law, morals, religion, very controversial issues. I know we all have our different religions. We have things what we call positivism. Positivism. We have what is, we look at what is the state, what's the country, what is it all about, what's law, what is law? That's what is law. Do you know what law is? What's revolution? If revolution comes now, we've had, God forbid, but allegedly there was an attempted coup. God forbid we should go back to military rule. That's regression in my view. But some African countries recently have had Mubarak's smart nota wants to record this meeting. What are you using our smart nota for? Are you going to publicize? Are you going to send it online or some nonsense like that? Mubarak, can you tell me the reason why? I'm not quarreling with you or anything. So we're adults. You're allowed to express yourself. Can I hear from Mubarak? Since Mubarak did not approach me before the class.
Yes, sir. Good morning, sir. I'm right here and I can hear you.
Okay.
Yes, sir. It's not for any illicit or illegitimate reason. I just wanted to take note of some of the things that I couldn't get with my pen and paper, essentially.
Yes, but would it not be also better that we all benefit from those notes? That be shared with your classmates?
Absolutely, I could if any of my classmates were interested.
No, not if they're interested. I want you to interest them by force, by fire. It's not competition. Okay. The ability to study is not, it's smart thinking, and I have no problems with your recording it for that. But I would like you to share it with your what's it called? WhatsApp group. I'm sure you have WhatsApp group. Okay, so I'm going to approve it. I'm not. I would trust you guys not to put stuff online, because sometimes I have to say one joke or the other. I don't want the joke to be misinterpreted or anything, or else we will not joke or laugh. We'll just be talking grammar. Which do you prefer? Let us know. Okay. Because classrooms become dull and boring if we don't have interludes from time to time. Because most of you are not even listening to me. Some of you are on your laptops or your phones or your, chatting away with your friends. You're supposed to be in class. Am I wrong? Don't forget that I have a super brain. I know what everybody is doing. Okay, I can even see you. Okay, moving on. Yeah, so what was I even talking about? I just told the different approaches that we need to look at and how law underpins society in many ways. So that's why we'll look at what the nature of jurisprudence is. What is the nature of jurisprudence? What is jurisprudence? Can we define jurisprudence? What is jurisprudence? Can anyone help us? Nobody?
So I think jurisprudence can basically just be called the philosophy of law.
Yeah, the philosophy of law. That's what it is. It's basically it's the study and theory of law. So we're not, as I said again, that we're not just looking at the rules and we're not looking at case law and the concrete things that we can see. We're going behind all those things, concrete things we can't see, to ask deeper questions and say, why is the law like this? Why isn't the law like this? So it's a philosophy of law, as you say. We are examining what the law is. Why do we obey the law? How does the law relate to justice? How does the law relate to society? What is that all about? So we'll be looking at what are the features of jurisprudence, what is it about? Okay? It's about ideas. It's about principles. That tells us why this particular law is like this. This was why I was trying to talk called the Land Use Act, and how they should function. I didn't want to critique the Land Use Act because I know many of you may agree or disagree whether the Land Use Act should be amended, but because of the sheer quarrels that happened over land matters, that's why the framers of the 1999 Constitution thought it best to enshrine it in the Constitution, meaning that it's so difficult to amend or modify. So what's the law? What should the law be? That means that you can you apply morality or ethical evaluation of the legal system? Does the legal system connect properly? Are we approaching law looking at it from the point of sociology? I've mentioned ethics. Is ethics part of the law? Can we have a law that is not ethical? Does economics, politics play a role in our understanding of the law? Because the law does not exist in a vacuum. The law exists within our own social and moral context. Is that also? And that's where things like rights. What are my legal rights? What are your legal rights? Where my rights start? Maybe that's where yours stop. What's justice? What's responsibility? Are we together?
Yes, sir.
Yes, sir. We're together.
So some of the things that we will look at is the arms of jurisprudence, of how jurisprudence has evolved. So one of the schools that you will look at is positivism. What they say, positivism. Positivism. It's analytical school, legal positivism. Basically, what this idea of jurisprudence is that it's talking about we should look at law as it is and not consider the morality of the law or whatever. Law as it is. It's only considered, it only considers law on the books as it is. And some of the key thinkers in that field will be people like H.L.A. Hart, Austin, and so forth. We will go into detail in all that. Then other schools says, no. I don't agree with where you're carrying these things to. Another school of law of branch of jurisprudence is the natural law theory. Natural law. Look at the word natural. What is natural? Something that comes with nature. And that theory, natural law theory, is arguing that law must be based on moral principles or universal standards of justice. You cannot have law without an underpinning of morality or a universal standard of justice. Law cannot exist without morality. So on one hand, legal positivists say law exists by itself. On the other hand, other thinkers like Aquinas, Thomas Aquinas, Finis, and so forth are saying that no, there must be an underlying morality to law. You have schools like historical jurisprudence that will look at law as part of people's culture, traditions, and history. So it's looking at law as a product. Is that your law will emanate from your culture, from your tradition, and from your history. For instance, we have the common law because we're a former British colony. It's part of our history, and that's part of our culture in many ways. Traditionally, we have our customary law, we have our Islamic law, and so forth. So that's also part of our legal jurisprudence. And you look at thinkers like Friedrich Karl von Sovny on this kind of point. We look at the realist school. We look at sociological jurisprudence. You know, sociological school jurisprudence will be thinking about how law affects and is affected by social conditions. You know, it's social conditions that drive the law. Look at people like Roscoe Pound, American jurist, so forth. So why do we study jurisprudence? Why should we go to school? Why do year 5 students have to study jurisprudence in order to become lawyers? I've said that that's the kind of questions we've asked in the past in an exam. It's because we need to understand the fundamental meaning of our legal system. what is the purpose of our legal system? Why does our legal system operate the way it is? It also helps us improve our legal reasoning, which we should reason properly and interpret law in a philosophical manner. I mentioned morality and social aspects, and jurisprudence will allow us to appreciate the moral and social underpinnings of our laws. It will allow us to develop critical and abstract thinking. And back to again that word abstract, critical and abstract thinking. Are we together?
Yes, sir.
No?
Yes,
Okay,
sir.
yes, sir. So when we look at that, we will say, okay, this law is a good law. That law is a bad law. So if you look at law as it intertwines with morals and religion, you see that we're sometimes on the slippery slope in terms of law, morals, and religion. These are very important issues that we must bear in mind. Is there any morals behind the rule, not a law, that says that law students in Nigeria should wear black and white? Is there any law? Is there any morality behind it?
So I think I've heard one before.
Go ahead, please go ahead.
There's one that says that because there is no sitting on defense, like there's no gray areas when it comes to the law. So what is wrong and what is right. So that that's the meaning behind black and white, essentially.
No. I'm asking that what is the moral issue in asking you guys in our faculty to wear black and white clothing?
So I have one. You can talk about it as a lack of freedom of expression among students.
How does that affect your morality?
Are
you going to go crazy? I mean, they say sometimes that I've heard people say, I strongly disagree, to be honest, because when I went to school, we didn't wear black and white. I was in the UK, but even in Nigeria at that time, nobody wore any uniform. Morals, is someone wearing black and white any more moral than somebody not wearing black and white? I'm aware there's some universities where faculties have adopted uniforms. In other universities, not our own. I can't remember what university it was, but somewhere in the south, people in I don't know whether it was sciences or something. They wore light blue. Basically, they just first shoved their morality down the throats of our students. I don't think morality that if you wear black and white, you dress in a more corporate and decent manner. What's stopping you from wearing a tiny white T-shirt that's very tight and a tiny black skirt? I don't want to use women as an example alone, or men to wear, what is it called, sagging trousers? Whether it's black or white, who cares if the trousers sagging and your boxer shorts are exposed to the public? So that interconnection, those we're looking at the law, morals, religion. These are systems of rules and values that guide human conduct in society. Basically, is that not so? Is what tells us what to do, what not to do. Is law, law, morals, and religion, are they the same thing? They are not. They are not, but they do interlap. They do influence one another, don't they? Okay. But sometimes it's from something that morality, religion will say, this is right to do, is moral. You accept that as a code of morality, and then that's now enshrined in law. So there's some kind of happy convergence sometimes. Sometimes, okay? Because sometimes our legal systems reflect moral and religious values of the community. Okay? So what is law? What is morals? and what is religion? Who wants to help me with what is law?
Good morning, sir.
Morning.
So, in my understanding, law is a set of rules, or law is a rule guiding people in a particular territorial area, or basically just shaping their conduct. And the way law is structured, because I align with the positive definition of law. So the way law is structured, there should be sanctions, making sure that these people abide.
Yes, fantastic. Well done. That's what it is. There are this set of rules that the state will now use to regulate our behavior, to maintain order, to maintain peace, to maintain tranquility. If you violate the law, there will be legal sanctions, fines, imprisonment, flogging. You go to Singapore, you get a flogging. Singapore prohibits and bans actually chewing gum in their country because it was costing them millions of Singaporean dollars to clean their pavement of chewing gum, and people used to stick it on the lifts and cause a lot of damage with it. So they now put it in it's in their law that if you're caught with chewing gum, which you are chewing everywhere in every state of every country that you know of in the world, and you're caught chewing gum in their country, you'll be doing what? You'll be flogged. You'll be flogged. They say putting you in jail means that you're just, you know, eating their food for free and everything. But when they cane you and you cannot sit down for several weeks, your head will reset your brain for you. You may not agree with the law, but that's their own law. Same way that if people traffic drugs into Thailand, death penalty, they don't play with it on the way out. But morals are not like that. Morals are not enforced by the state. Morals are basically enforced by societal approval or disapproval. So if you're not, it's not illegal to wear miniskirts, but you will find people staring at you. Some old women may even come to the girl and remonstrate with her. I've seen, I read, I didn't see, I wasn't there. An unfortunate, very, very unfortunate situation where because a lady was wearing such scanty clothing, women, no, not men, no, they were encouraging the motor park touts to tear her clothes off her and almost rape her. It's a very disgusting and very evil thing that you see. How do we talk about law? What about when you say jungle justice? Someone steals a loaf of bread in the market because they are hungry, and a mob descends on them and beats them into a coma. That moral? Does any religion says that you have the right to go and descend on anybody and beat them into a coma? Yes, religion is a set of beliefs about divine or sacred. And in Nigeria, we have traditionalists, we have those of the Islamic faith, we have Christians and all sorts of religions that, you know. So you now see how even this, I mentioned natural law theory earlier on, where people are saying that law, as a matter of nature, is deprived from morality or divine sources. I mentioned Aquinas. So if a law is on, according to those kind of thinkers, if a law does not conform to a moral or religious standard, it's not valid. Can you argue that in court? That this law of the Federal Republic of Nigeria, this local government law or state law, is not in accordance with my morality, and therefore you can't apply it to me. I think it's very difficult to argue that. However, the positivists like Austin and Hart say that law and moral are totally different and separate. Okay? Laws are valid not because of any morality or religion. Laws are valid because it is made by the sovereign or a recognized authority. Are we together? Hmm?
sir.
Yes, sir.
Okay. What about human rights? What about human rights? Is it based on morality? I have thought modern human rights law have some element of universal moral standards that we should not torture people, we should not murder people, and it has elements of religiosity in terms of respecting people just because they're human. What about morality of abortion? Abortion rights is a big problem now. If you go to America, Roe versus Wade that allowed women to do abortion for many decades has been curtailed by the Supreme Court of America. In Nigeria, abortion is illegal. Other people will argue that when you're making abortion illegal for your morality, many young women and many women are dying needlessly in the hands of quack abortionists, quack doctors, quack nurses who are destroying their wombs and killing their future. Is it better to regulate abortion and allow abortion or to strictly ban it? These are part of the arguments that you find in every society. What about homosexuality or same-sex marriage? Is it something to tolerate? Same-sex marriage is against Nigerian law. Other countries say, like South Africa, will accept same-sex marriage. Say marriage is marriage. What about the morality behind euthanasia? Someone has incredibly painful cancer. They've been crying and they've been in pain for the last 2-3 years. Even all the modern medicines can only relieve them to a certain level. Should they be allowed to die with dignity? Or must they be forced to stay in the world because of our society's morality that nobody should be allowed to commit suicide? Is suicide not against Nigerian law? Is suicide not against Nigerian law? Sorry?
It is, sir.
I thought they said there's talk about reforming that.
Only
So
in
even you don't even own your own life. Your life doesn't belong to you. Should the state be so powerful to say to somebody that you jumped out of the window to commit suicide? Sadly for you, you missed this iron spike you want to use to impale yourself on. Now you're going to jail to go and to go and think about your mistake. What about the whole issue about whether countries should be secular or religious? Nigeria's had this endless battle of secularism against religion. The constitution says we're a secular country, yet religion is making its way a headway into every aspect of our lives. We have our Sharia states, despite what the constitution says. If the constitution is the good norm, are those states in compliance with the constitution? Should the state be neutral, or should it be guided by religious rules and edicts? If you go to Saudi Arabia or you go to Iran, these are theocracies where religion is king. Are the people any more religious as the king, as their country is all about religion? Are they better people than we are? What this course is about is I want to learn to think. Thinking is very difficult. Many of you don't want to think anyway. I want to do what? Learn to what? I want you to learn to think. Are we together?
Yes, sir.
Yes, sir.
You're not afraid of thinking. Talk about law and justice. It's one of the biggest, oldest debates in jurisprudence. Law says that this is my rule. Do this, and you're in trouble. It's enforced by the state. Don't drive whilst drunk. It's a law. If you breach the law, you can be imprisoned. If you kill somebody, God forbid, while he's drunk, driving a car, wahala, trouble. Meanwhile, justice is like an ideal that what the law should achieve. Does law and justice always mean the same thing? Sometimes people are convicted and people say there was no justice. The law says do not steal. The law says what? Do not steal. Raf, are you in class? Raf, are you in class? Jimmy Bada, Oluleke, are you in class? Anita Spence, are you in class?
Yes, sir.
Is that Anita Spence speaking? Okay.
Yes, sir.
Yes, sir.
Many of you are not in class. They're just playing around. So Anita Spence, I'm talking to you now. The law says do not steal. Is that correct?
Yes, sir.
If somebody steals, what will be the consequence?
They could be locked up or lynched.
They could be what?
They could be locked up or lynched.
Lynched. The law says you can lynch people. Hey, what kind of students do I have? Oh? The law does not say you can lynch anybody. Oh. I'm not aware of any law in Nigeria or any country where lynching is an acceptable way of doing things. Hmm? You don't lynch. What does the law do when somebody commits a crime? It can punish you. It can fine you. It can put you on probation. It can imprison you, but it cannot lynch you for crime. So, who am I speaking to again? What's your name again? Remind me. Anita.
Yes, sir, I'm here.
A man lost his job 8 months ago. He has been struggling to find a job day and night, not being able to find a job. He hires himself out as a laborer. He will do cleaning work. He will do any work. He's not too proud. 3 days from last 3 days now, he has not been able to find any work. He has 2 children at home and his wife. They are crying in hunger. They are crying in hunger. So he went to the market to look for work, and he was not able to find any work to carry loads or whatever. He now went past a store selling bread and sneakily grabbed one of the loaves and put it in his bag, and he was caught and taken to the police station. What should if you are the DPO or sergeant or whatever in charge of the police station, what would you do?
Well, judging from his just his life in general, as a first time offender, I wouldn't really know, but this is the first time I'm hearing or seeing him still,
Okay.
and he's been caught. So I would actually apply some sort of mercy to him, and if possible, if God tells me to, I settle the
you're now a judge to apply the prerogative of mercy. Okay, continue.
I would settle the vendor that he stole from
Out of your own
if I
pocket,
feel
Abby.
yes, actually, because
What
that's
a
what I would
wonderful
actually
police
do.
officer you are. Who has a different view?
I have a different
I
view.
do, sir. Oh,
Pick
okay.
up, yes. Go on. I'm listening to you.
So the truth is that the scenario you gave now, there's a high tendency that as the DPO, I don't know all of this. His family is suffering, his family is going through this.
Yes.
Technically, that's not my business because the person he stole from, that's also the person's hard work.
Yes,
so,
absolutely.
like Anita said, yes, the person is a first-time offender. So I will be lenient, but he will have to serve something.
But is it your job? Is it the job, or is that the job of the police officer? I mean, I know what you're saying is actually what happens in practice, but is it the job of the police officer to apply the law or to enforce the law?
I can't apply the law, but he will be detained now.
He'll be detained, so he's going to go to court. So if he goes to court now and you're the judge, what would you do?
You have to take a lenient, like I'll be lenient with the sentence I'll give him because it's bread now. It's bread.
Say what you would do. What sentence would you give him or her?
He would, we just try to settle it and make sure that okay, he refunds the person that he stole.
He has no money. If he had money, would he still look for bread?
So that one does not concern me now. I have to, apply justice where justice needs to be applied.
Okay. All I've just done with this scenario is to tell you that how law may conflict with justice. If the law may say that you should imprison the person for 2 months or whatever, if they commit this offense or whatever, and the reality is that it may not be just. So that law and justice are two different things. What about when you have apartheid laws as they had in South Africa? Should I, as a black person, be told have to accept this kind of unjust law? Is it the law that will apply? What about slavery laws, colonial decrees? People come to your country and take it over, and then they're not telling you what to do in your own land. You can see what's happening in Gaza with the Israeli people and the Palestinians. What about the Nuremberg trials after the Second World War, where Nazi officers were saying, all I did it according to the instructions of my boss. Then they said, no, that these are crimes against humanity. Your boss cannot tell you to behead somebody because they are black or they are Jewish. That's not lawful. You cannot obey, you're not supposed to obey that kind of laws. Martin Luther King has said, we have a moral duty not to obey unjust laws. So there's a whole gamut of different approaches to this concept. Are we together?
Yes, sir, we are together.
Yes, sir.
Okay, so we understand where we are. So, how does the law work? How does it deal with society? How does it deal with issues of legitimation? So, jurisprudence will say, how will the law survive if there's a revolution? How is the law transformed if there's a revolution? And how can a new legal regime become accepted as legitimate? So a revolution is something that will challenge an existing legal and political order. It will overthrow the constitution. The 1979 constitution was minding its own business and going along until a coup happened in 1980, 1979. When was the coup? Was it 1983? 1983. Yeah. I want to test those of you who read newspapers, not just Genevieve's magazines. So a coup comes up and scatters everybody. Federal military government hereby decrees as follows. They don't waste time. You're out. It's a radical and often violent change of the legal and political order. So the government is gone. The constitution is gone. So that would have political consequences, constitutional consequences, of course, social consequences as well. So when you're talking about legitimation, it's basically a way or legal order whereby a law or a regime gains some moral and political acceptance from the people. Why should the military government be able to overthrow, not government, military officers, be able to overthrow a regime that was actually voted for by people? They were never voted for. But then if, as happened in 1983, there was a disputed election, rigging, and all that kind of stuff, so the law ceased to function. The law no longer had legitimacy in the eyes of the people. It's the same people that will come out to celebrate the overthrow of the constitution, that will come out later on to say the military are evil and they don't consult them and they just do what they like. That's why you see the military go around co-opting traditional rulers and all the instruments of state to pretend to get some kind of legitimacy. So when you have a revolution like that, an overthrow of an existing order, you have abolished the old constitution, you abolished and potentially some of the old laws, and you now establish your own new laws and institutions. When you have military governments, for instance, they don't have a legislature. It's the one thing they don't have. There's no legislature. They have an executive, and judiciary continues, but there's no legislature. Historically, we have the American Revolution. We had the French Revolution. Away from the colonial rule of the UK, of Britain, and established their own constitutional democracy. The French Revolution overtook in 1789, destroyed the monarchy. In Africa, we've had independence movements that helped us gain independence. In some countries like Mozambique, they had to fight wars of independence. Frelimo, go and look it up. Okay. So if we look at jurisprudential perspectives, you say this legal positivists will still argue that law is valid when it emanates from a recognized legal authority, regardless of whether that legal authority how they came to power. It doesn't matter. If you're a recognized legal authority, then the law is valid. So after a revolution, after a coup, the new regime's law will become valid so long as they are effectively enforced and they are obeyed. Meanwhile, the natural law theorists will say, how does morality work with your revolution? It will argue that a revolution that restores justice, e.g., it ends oppression or tyranny or whatever, is legitimate, while another one, it will not be legitimate. So if your coup leads to injustice, it cannot produce a valid law. I think I mentioned sociological perspective. I didn't mention Marxist theory. The Marxist jurisprudence, everything they see is about class struggle. Everything is class struggle. That the ruling class always exploits the working class, and they look at everything through that prism, through that looking glass of class struggle. There's nothing that Marxists know other than that one class is chancing another class. Do you agree that's the case? Hmm? Are we together?
Yes, sir.
Yes, sir.
So, let's move on. We'll also be looking at the judicial process. What is the judicial process? How do judges find and interpret the law? Does morality play a role in judicial reasoning? So someone's before you now, Mr. XYZ, you are caught stealing a loaf of bread. Does morality play a role in the sentencing? All of it said you will be liberal, you will be mindful, you will be sympathetic to the thief who stole the loaf of bread out of desperation. What if he stole Apple iPhone 20 because his girlfriend demands it? Would you show the same level of compassion? Does morality play a role in judicial reasoning? Does policy play a role in judicial reasoning? Does social factors play a role in judicial reasoning? Would you say because the person is young and he wants to please his girlfriend or boyfriend or her boyfriend, they can go and steal, go and provide money for them? Would you, as a judge, consider that as a mitigating factor? If that mitigating factor has not been spelled out in any guidelines given to the judiciary? So the judicial process basically is the methods, reasoning, and principles through which the judges will interpret and apply law. And they will use it to decide cases. It's not about the processes of court, or it's not about the rules of court that you go and read. It's about the philosophy and theoretical foundations of how judges make decisions. The philosophical and theoretical foundation of how judges do what? Make decisions. Why do we need to understand this? Because how judges make decisions is critical to the legal system. Our judges, should there be judicial creativity? We had the famous law Denning. Or should they strictly follow the law? What is the role of precedents? How should we look at precedent? Jurists like Sir William Blackstone have always said that judges do not make the law. They merely declare what the law is, or what the law has always been. This kind of reasoning just says that law has always been there, and judges are only going to uncover it through interpretation. But the fact is that when law is ambiguous or outdated, sometimes judges do create new legal principles. So that judicial creativity, should it be acceptable? It is if the statute is silent and there's no case law to help, what should they do? So legal positivists will look at, like Hart, like Austin, will look at judges as interpreters of existing law made by a legitimate authority. Yes, you must have judicial discretion, but only exists within that enacted law. It's not for them to create what they like. But the natural law school, again, I say I keep bringing you to the same things, which says that we should interpret laws in accordance with moral and ethical principles. If a law is unjust, judges have a duty to interpret it or apply it in a manner that will be consistent with morality and justice. Does that make any sense? Are we
Sorry,
good?
sir, I don't.
Yes, go ahead.
Sir,
What are you
I
saying?
don't think I the statement you just made on.
Can you please speak properly? I can't hear you. Your mom.
Like, can you hear
If
me
you're
now?
using earpiece, remove it. I can't hear you. Go ahead.
How about now? I was saying that I don't think I understand the part of judges making interpretation of laws where there is no, where there have not been any case law as regarding that particular situation.
So if you're a judge and there's a law, but that law does not cover that particular situation, you will just do what? The particular issue, the law, there's a law on the issue, but it doesn't cover the entirety of this particular case or circumstances that come before you. Will you not interpret that rule, the rules that already exist, to cover that? Or will you say, oh, I can't do anything about it, let's take it to the National Assembly to make a new law? You will do something now. As a judge, you have to decide on the particular case. That's why in reality, sometimes judges do make new law, create judicial creativity. It does happen. You may not agree with it, but it does happen. That's why those who are from the school of legal realists say that judges, they focus, those realists like Carl Lewin, will say that judges actually decide cases, not how they say they do it. The reality is that they are influenced by their own personal values, by public policy, by practical outcomes. They don't talk about law in the book. They're talking about the law in reality. These people just, you see, a judge that comes from, that's why they say sometimes judges you must appoint judges from different parts of the community. If all the judges are multi-millionaire backgrounds, can they really identify with some of the struggles that people are undertaking? I read something online how because President Trump had grown up with the son of a multi-millionaire. He had never gone to a grocery shop to purchase things, so he doesn't know how expensive things are. That could maybe a legitimate or illegitimate criticism. We don't really know, do we? I can tell you of what happened to me on Sunday, just this Sunday. I went to buy a bottle of Coca-Cola, and I stopped my car in the side of the street, and I asked for a bottle of Coca-Cola, and she said 500 naira. I frowned at, is this woman trying to cheat me just because she sees me in a car? I did not know that a bottle of Coca-Cola is 500 naira. I didn't know. So it's just like even your own lecturers can be out of touch. Yeah? I didn't know. No idea. No idea at all. Very alarming. I was very alarmed. As I said, I zoomed past the woman. That this, why would someone try to cheat me because I'm in a nice car? You think I'm a fool or something? What kind of rubbish is that? Are we together? Are we together, Sars, Ma?
Yes, sir.
Yes, sir.
So all of you are none of you are out of touch. You all know what's going on.
Very much
Yes,
so.
sir. Very much.
I don't believe you. I don't believe any of you.
Sir, the economy is touching all of us.
So you know that the bottle of Coca-Cola is 500. I did not know now.
We watched it grow from 350 to 500 overnight.
Well,
Actually,
I watched it at 30 kobo. So don't worry. Let's not all complain. It was 30 kobo at one point. You buy it and you buy a bread, and that will be 50 kobo, and you are done. That's a nice little lunch. And that your bread will come with blue band or something. All right. So the last topic there is on, I think, fundamental legal concepts, and this is actually something that comes out every year usually. Say, telling you by force by fire usually, and in the it's a very interesting part of jurisprudence because it refers to ideas and foundational legal thought and reasoning of how law works. And we are looking at the work of one particular author. And that author, or that jurist, or that thinker, or that philosopher, whatever you call him, is Hufeld. Hufeld sat down and tried to break down fundamental legal concepts. I'm not going to tell you everything about Hufeld. This is just an introductory class. You have, I think, Professor Dr. Ebinedion for that. Okay? What's a legal right? What's a legal right? Now try to break it down to how it can operate. So it broke down rights into basic legal patterns. When you have a right, you have a duty. Where you have a privilege or a liberty, you have no right. Where you have power, you have liability. Where you have immunity, you have stability. So basically, if I have a right, you have a corresponding duty. I have a right to do this. You would have a corresponding duty to do something else. If I have a liberty do something, you don't have a right to stop me from doing that thing. If I have a power to change legal relations, for instance, you will suffer that change. You will be liable to, if I'm a legislator that creates a law, you, the people, will have to obey that. If I'm immune from something or a change, you don't have a right to prevent my immunity. It's a bit complicated. I advise you to take your time and read it. Don't leave it to the last minute. Read ahead and dealing with issues there of clarity, of precision in the law. What does the law mean when you're talking about person, ownership, property, command, rights, duties, liabilities, immunities, privilege? All of these are key and very important legal concepts that we need to do. So, in this course, your lecturers are myself. I will handle topics 1 and 2. Nature of jurisprudence, law, morals, and religion. 3, 4 is likely to be Caribbean White, Dr. Caribbean White. 5, 6 will be led by Dr. Igbini Dion with the assistance of Mrs. Adedeji. Okay, so 3 lecturers. We are blessed, aren't you? Now, I will have a class with you next week. So I assume it's a physical class and you all be ready, bushy-eyed and tailed to all come to school because I don't know why there was some kind of last-minute problem. Your attendance, some of you should have been repeating. So if I were you and you dodge the bullets, don't be foolish, oh. Don't be foolish. Don't be in Dubai while we're having our class, oh. Okay? The word is enough for the wise. If you come crying with your parents, it will not work. So I wish you all well in that. So that's the topic. Those are the topics. Read ahead. There are just some kind of class note things that they copied down, that was copied over the years from Professor Ibodi that I know you all read. So I always try to, because for the sake of not forcing you to go and get several books, try to use that as a guide for everybody. I think that's very useful. Are we good with that? Is that okay? I know you like easy things.
Yes, sir.
It's your reading ahead that will matter at the end of the day. So I look forward to seeing you in the next class. And after the next class of next week, I'm going to be out of town. So I will have to do some classes on Zoom. I will be out of town. Okay? So I'll have no choice but to. Yes, please go ahead.
That this jurisprudence class, is it only focusing on Nigeria?
Is it only focusing on what?
Focusing on Nigeria. The scope of jurisprudence is it only on Nigeria?
Oh, it's philosophy now. So you can give examples, but we mostly want our local flavor, of course, yeah. But if you have an example, I was talking about abortion. I mentioned Roe against Wade, a famous American case. It's not a Nigerian law case, is it? So you use different things, but of course you want to be grounded in your own reality. Otherwise, how would you apply it if you don't know what your own reality is? So that's why I mentioned the Nuremberg trials that all happened after the Second World War. These are all things that impact us in Nigeria. I think we have run out of time, haven't we? So on that note, I thank you all so much. Do I thank my students for coming to class? Are you not supposed to come anyway? Less than 200 people, but anyway, we thank God. So class rep is recorded. You have your attendance and all that. And I thank you all again. Have a wonderful day and happy Wednesday. Lovely. Thank you very much.
Thank you, sir.
Thank you, sir.
Thank you, sir.